Good morning, members of Parliament, support staff, visitors in the public tribune, and those following by various media. Welcome to this meeting of the Committee of Constitutional Affairs and Decolonization, number 3 of today, Tuesday, April 4th, 2023. We've established a quorum of 8 members. Please stand for a moment of silence. Thank you. I've received notice of absence from MP William Marlin, who is on Parliament business. I also received a notification from MP Emmanuel that he would be absent, although he's not a member of this committee. And I did also receive notice of lateness from MP Westcott Williams. Are there any other notifications? Thank you, members of Parliament. The agenda points for this committee are discussion regarding follow-up on the petition submitted on behalf of Parliament of Sint Maarten. This is IS 524, dated March 1st, 2023. Follow-up discussion regarding reparatory justice and debt cancellation post-IPKO. Discussion on the creation of a multi-annual comprehensive plan for decolonization in accordance with Resolution 1 of the June 23rd motion of Parliament. This is IS 971, 2019-2020, dated June 23rd, 2020. We go over to agenda point 1. The Parliament of Sint Maarten received a request from Mr. Peter Harris. This is IS 524, dated March 1st, 2023. As members of the committee know, he was contracted previously to execute, among others, the submission of petitions to the Special Rapporteur on racial discrimination and xenophobia. Mr. Koharis has requested to be able to continue on behalf of the Parliament of Sint Maarten with regards to follow-ups regarding the petition. I had informed Mr. Koharis that any future action regarding the petition, the Parliament should be consulted, and such consultation should begin within the next CCAD meeting, hence the agenda point for today. The question to committee members is whether the Parliament should consider re-engaging with Mr. Koharis. To be clear, he has offered currently to do the current follow-up at no cost, but it cannot be ascertained if in the future there will be any request for charges for future action, so if it will come at a cost. There are various options for the committee to discuss, whether we should first accept Mr. Koharis or different options. Mr. Koharis requests to continue follow-ups on behalf of the Parliament, to not approve the requests and perhaps do the follow-ups ourselves, or whether we should discontinue action related to the petition. These are some of the options, and other options are welcome from the members of the committee. As there have been differing views in the past related to this petition, I find it prudent to hear from committee members and have an advice created for the Parliament to decide further on action related to this petition. Members of Parliament, that is the elucidation on this agenda point. To whom can I give the floor regarding this agenda point? Anyone? Yes, MP, we have MP Grisha Heilige Martin, then MP Gums.
Thank you, Mr. Chairman. Good morning to everyone. Good morning to you, my fellow colleagues, and to our reps of the Pro Swaliga in the Tribune. Mr. Chairman, just for clarity's sake, what exactly is Mr. Koharis requesting? Because it first stated that he would be doing it, follow up on the 2 existing petitions. That's what he's asking of us, and there might be future financials tied to it with the follow-up. It's not clear. So is the follow-up, because I mean, the follow-up is something that we would need to, of course, continue because we have the 2 petitions in. But I mean, I'm trying to understand the financial part of it, if you could be more clear about that.
Sure. What he has proposed in his email was to do a current follow-up, so contact the Special Rapporteur to ask for an update, which he has stated he would do at no cost. Why I put here that it is not clear as to whether he will be sending a future proposal where for further work, if there's going to be any other requests for a contract and so on, that is not really clear. This is about whether he is to be allowed to, on behalf of the Parliament, be in touch with the Special Rapporteur. And as I said, I felt like it would be prudent to hear from the members of the committee if that is something, an action that the committee feels we would like to allow, that Mr. Koharis, on behalf of Parliament, would be able to be in touch with the Special Rapporteur regarding follow-ups. MP Gums?
Thank you, Mr. Chairman. In all honesty, I think if we consider reading the email that he sent, the ongoing conflict between Russia and the Ukraine and other geopolitical realities taking place, I actually do not think that keeping him on for follow-up would actually yield much of a feedback. So I think if he wants to do this one follow-up pro bono, I think that should be it, because I personally don't believe it's going to go further if I look at how situation is developing for the UN then in Ukraine and Russia. Thank you.
Indeed, that was a point that he did bring up to add some context to what the special rapporteur may be preoccupied with. I see MP Grisha Martin would like the floor again.
Yes, Mr. Chairman, I just wanted to actually respond to your clarification, just to also state that indeed, if he wants to follow up pro bono, that would it would have my support to at least just one more follow-up and see what we yield from that. But other than that, given the fact that we've cut so much from the budget, I don't see us maybe hiring him anytime this term, given how the budget is cut. So for that, maybe just a follow-up would be fine with me, Mr. Chairman.
Okay, just to be clear again, there were also questions in the past about whether this is someone that would be on behalf of the Parliament of St. Maarten doing the follow-up. So I need to be clear about what exactly are we mandating him to do. If he's approaching the special rapporteur, will he be doing so on behalf of Parliament? What communication exactly is this follow-up going to entail? Do we want to ensure that it's boxed in? But that is also why I put as an option, should consideration be given for the Parliament doing the follow-ups and communications with the special rapporteur to avoid any of the sort of discussion as to whether he can represent Parliament or not, pro bono or not. He will be saying on behalf of the Parliament, I would think he needs to say, I am contacting you on behalf of the Parliament of St. Maarten to inquire about XYZ. I would think that that is how the communication was done. So I just would like some clarity to be clear what the opinions are on that aspect as well. So I can understand that some feel, well, if it's pro bono, it might not hurt, but can he do so on behalf of the Parliament of St. Maarten? I see MP Peterson.
Thank you, Mr. Chairman. Good morning still to everybody, all my colleagues, those in the Tribune, and everybody else tuned in. Mr. Chairman, that would start, the same debate that we had when we had Mr. Harris here, and it's basically going to be a circle again, in which I personally am of the legal opinion that no entity can represent Parliament in that way, as per the Constitution. So, to kind of read this out, I think that we should consider, like MP Grisha Martin said, whatever he can do pro bono, but make it clear that he understands what our Constitution says and that what he is doing or has been doing is legally questionable. But other than that, I believe that we are already on the trajectory. So to round it off in a way that we can at least not have more ruimte for interpretatie. So just for to give that note. But like you said, Mr. Chairman, we as Parliament cannot be represented internationally in that sense, according to Article 44 and the Memorie van Toelichting on it. So just a note on that.
Okay, just maybe you can clarify for me, because maybe I misunderstood. It seems a little bit contradictory, because if we allow him to go pro bono or not, will he be doing so on behalf of the Parliament of St. Maarten? And if there's a legal question there, I would like some clarity on that, maybe if you can elucidate further, MP Peterson.
Yes, no, I think that last time that we had him here, that point was severely debated, and I believe it's a matter of opinion at this point. If it was not black and white then I don't think that it would be black and white now. I made my opinion clear, PFP made their stance clear, that no legal entity in that way can represent us, but the Parliament, to their respect, decided to move forward with it, and that is something that has to be respected. So I don't think my legal opinion right now is going to change the trajectory that we are going to walk. I just think that we need to round it off in such a way that we don't have any, that we have to do damage control after. Yeah.
Okay.
Thank you, Mr. Chairman.
Thank you. What about consideration for the fact if this is one follow-up, but in terms of, I would expect, especially as MP Gums mentioned, a follow-up right now might not yield much results. Should the Parliament itself just maintain the contact with the Special Rapporteur going forward, where we ask Mr. Harris to simply hand us the contacts, the information, the communication, and then we continue the follow-ups going forward. If that is now maybe a better route, like you said, it was heavily debated, and that is why I chose to say, look, before the Presidium, which would be the contracting agency, even if it's pro bono, we would have to have some sort of agreement with him to allow him to do that. Rather than going through that route, should it be better then that we simply say the Parliament would continue the follow-ups? What are the opinions of that? Is that, yes, MP Rumo?
Pleasant good morning to you, Mr. Chairman, to the viewing, listening public, and of course to my colleague MPs and to those in the Tribune. I would want to agree with your suggestion, Mr. Chairman, based on MP Peterson's elucidation. Indeed, if it is so that this gentleman legally does not represent Parliament, then I believe the correct route would be for Parliament to do the follow-up instead of going through him, even though it would be pro bono. So that would be my suggestion on this.
Okay, like MP Peterson said, I think it's, let's say it's been debatable. It's been debatable because you do have situations where the Parliament can ask or hire an entity to be in contact with certain things. Of course, the nuance here is whether in dealing with an international organization you would have so, but the Parliament in the future may contract legal personnel to be in touch with, let's say we want to change a labor law and we have an ILO situation, we hire a lawyer, that lawyer then might interact with the ILO to then come back with us. The legal nuance that MP Peterson and myself have continuously debated, and I think he's conceding that it is a debate that needs to be figured out. But let's say if you want to avoid that debate altogether, the option could then be, as what you elucidated, that simply we do the follow-ups going forward in this particular case, and in future, if the Constitutional Affairs Committee maybe feels that, hey, further action is needed or more legal work is needed, then I will do just as I did today, come back to the committee and said, look, based on what we receive from the committee or the special rapporteur, we need a lawyer to interpret this, therefore we will the Presidium would then follow the procedures for contracting a lawyer, and then we go from there. So I see MP George.
Yes, thank you, Mr. Chairman. Just to add a bit, this discussion has been, when I say discussion, has been ongoing for quite some time in regards to the form of Mr. Koharis. My question is, Mr. Chairman, based on the past, we had a contract with him, I believe. When I say we, I'm not sure whether it's the Parliament who signed the contract. But is that contract still valid, or was it based on a particular task that had to be done, and definitely it's over now, right now, and he can on his own do work pro bono without us actually being part of it. So my question is, the contract that was signed or whatever, I think we had one, has it expired already or not? That's what I wanted to make sure. Thank you, Mr. Chairman.
MP George, I don't have the exact information in front of me. I think, I can say I think, but I will follow up. I do believe that the contract had expired, which is why he's asking to re-engage. And yes, even if pro bono, he would need to have some sort of agreement with the Parliament to do so. However, hearing the suggestions, and I didn't hear any objection to that proposal, where the Parliament would then be in contact with the Special Rapporteur to get the information, and if that information requires any further follow-ups, we will then again consult with the committee on what should be the next actions in terms of contracting a lawyer and so on, if necessary. So with that then, what I would then propose is that, 1 second. Being that this is being handled in the Kingdom Relations, the Constitutional Affairs Committee, would the committee, let's say, agree with me being able to have the contact together with the President of Parliament and then reporting back with whatever is received and book it in as an IS to this committee? Yes? Okay. So as chairman of the committee, together with the President of Parliament, I will do the follow-up, and whatever responses are received, even if they're brief, if they simply say, well, we don't have no answers as yet, that would be booked in. If they have a more in-depth report, that will also be booked in for the CCAD committee, and then that will be handled further. Any other points on this? No? Oh, MP Rumo?
Yes, Mr. Chairman. Also that you inform Mr. Koharis of the decision taken by Parliament.
Yes, so based on this decision, the Secretary General will, together with the Chair of Parliament, communicate with Mr. Koharis regarding the decision of the committee. We go over to the next agenda point. Agenda point 2 is a follow-up discussion regarding reparatory justice and debt cancellation post-IPKO. As many members are aware, during the last IPKO, reparatory justice and debt cancellation in the context, reparations and debt cancellation in the context of reparatory justice was part of the discussions. The IPKO decided that at the next IPKO, the IPKO will, quote, go deeper into this subject of slavery. While the Kingdom Relations Committee typically deals with preparations for IPKO, as this committee has been engaged on the subject several times before, my suggestion is that this committee prepare positions regarding reparatory justice. This discussion can be open today with the opportunity for preliminary discussions, after which it can be adjourned to allow the opportunity for further discussions in this agenda point. The proposal, however, is that this agenda point is closed with some time before the next IPKO so that a report can be created and forwarded to the Central Committee and possibly a public meeting where Parliament may have some positions regarding the subject of reparatory justice. To start the discussions, some questions to consider. Is the CARICOM 10-point plan an appropriate framework for reparatory justice? To what extent should reparatory justice be coupled to the apology for slavery? What are the financial and non-financial components considered to be part of reparatory justice? Do factions have a position regarding an approach at IPKO regarding reparatory justice? And what is the opinion on debt cancellation being seen as a sort of down payment, quote, or a first step in regards to reparatory justice? I pose some of these questions just to kind of frame the discussion and get that going. Like I said, this agenda point will be adjourned, which we can come back to. Others can do some more research. You can discuss within your faction or, well, in some cases with yourself, based on what the positions may be or what you would like to add to the discussion. Maybe also other questions or considerations we can add at this point. To do that, also some of the sentiments that were expressed at IPKO maybe can be delved into deeper here. I know Py22-23, Py22-23, myself, and several others did chime in on this issue. So let's have the discussion within this committee, basically, and then start to form maybe more clear discussion points to prepare for the IPKO, rather than what we've done in the past, which is we have a Kingdom Relations Committee and we kind of put a speech together. I'm trying to be a little more proactive ahead of the next IPKO. I see MP Gums would like the floor.
Thank you, Mr. Chairman. And this is just going off of the last statement that you made. Is it maybe then an idea that whether it's members of the committee or all the factions in Parliament submits maybe a 2 to 3 pager of their actual position, instead of just, because sometimes you'll say something in a meeting and I know it happens to me that afterwards I'm like, oh, could have said this also. That way you get the opportunity to at least put down all your thoughts in a concrete format, and then we can maybe discuss based on that moving forward. Thank you.
Yes, I think that's a great suggestion. I think we can do a little bit of both because some of these subjects are debatable. So maybe once the position papers are there, we can exchange ideas, have those discussions. Maybe at some point even we can, I know they're very popular in this committee, but they have really kind of, in my opinion, cemented themselves as very knowledgeable on the subject of reparatory justice. That would be the 1SXM Association, but perhaps there are others. There's also the committee, what was the name of the committee, MP Duncan, if you could help me out, that the slavery committee that was yeah, I think everyone remembers the committee I'm referring to that was established by the Prime Minister. Perhaps hearing from them would be another idea as well. But the idea is that this can be a continuous discussion ahead of the next IPKO. And indeed, if there's no objection, we will then ask each faction to submit a few of their points in writing regarding to this subject as well. I go now to MP George Pantoflet, and one of the points, MP Pantoflet, that I noted here was regarding your discourse on how you, at the IPKO, in my opinion, kind of interestingly tied debt cancellation now actually to reparatory justice. So look forward to your contributions in that regard. I give you the floor.
Yes, thank you, Mr. Chairman, and good morning to my colleagues once more and those that are viewing and sitting in the Tribune. I would be brief as possible because quite truthfully so, Mr. Chairman, during the IPKO meeting, I brought forward some of those points, which for me I find is very important. And just to give the listeners or the viewers just a brief idea or synopsis as to why I came to that point, it was in 2020 we were dealing with the, I believe, the 2020 budget. And in reading the report, the IMF was quite clear when it looked at our GDP, stating that if the Dutch government continues to give us loans, it means that Sint Maarten will never be able to repay them, as a matter of fact, and also not return to the pre-COVID or whatever status. So what I did, I looked at the budget itself, and then I discovered that we owed 1.4 billion guilders in debt, and we were paying 12.7 million guilders on an annual basis. If you do the math, you realize that after 80 and 90 years, you're still paying. So what I did during the IPKO meeting was to highlight that point. And the issue of this has to do with, and I'm glad that the Prime Minister established the committee, is tied into slavery, because if we are true to ourselves, poverty that exists today has a lot to do with slavery. Definitely based on the fact of we are never able to develop ourselves to the point where we would have been had there not been any slavery. So I think that based on what you said, Mr. Chairman, I'll try to leave it at that, but important for the public to know that we definitely have to pursue this matter, because I'm not only looking at the debt cancellation, Mr. Chairman, but I'm looking at also the issue of local debts that is owed to APS, SZV, and so on. If you look, and curiously enough, I just looked at the point number 10 on the Curriculum Committee Operations agenda, and realized that they mentioned also local debts. So I said that's very interesting, because prior to that I had already looked at it. So when I see it, I said, okay, that confirms my sentiments, because whatever debts that we have right now, they are responsible for the fact of how we're treating slaves. So, Mr. Chairman, I'll leave it there, because in the other faction would be able to put things on paper, as you said, and I'll come with more information, more clarity as to how I personally see that we should proceed with this, because I call these known figures, I call them the low-hanging fruits. Thank you, Mr. Chairman.
Thank you, MP Pantiflet. And as was suggested earlier, would you, through your faction leader, be willing to put those points on paper? Yeah, I hear, of course. Okay, very good. Next, we have MP Solange Duncan.
Thank you, Mr. Chairman. I just wanted to chime in first to say a good idea, because indeed we should be more prepared. I also echo the sentiments of MP Gums. I was thinking the same thing when she said it. Position papers would clearly articulate our stances as factions. It would also be good for the general public to know and understand exactly how we feel. And also, too, I just want to say that we have a very unique opportunity here to shape the narrative from our perspective. So what is Sint Maarten's perspective? Then within a greater context, so-called Dutch Caribbean perspective, because we are influenced by our Caribbean brothers and sisters, but we are in a very unique position right now. And the region is looking at us. So from our unique perspective, I think it would be great for us here in Parliament to put our thoughts and ideas on paper and then debate them and then be prepared and hopefully present whether it's a united front or at least an organized front for IPKO. I think that would be good, but also too for the general public. Thank you, Mr. Chairman.
Thank you, MP Duncan. I will wish us luck on the United Front path, but you never know. But seriously, though, MP Duncan, that is why I think it's good to have more of that debate here. I think it also helps us going into IPKO. Even if there are dissenting views or differing opinions, then at least those have been debated more so here than on the floor of IPKO, where, of course, different delegation factions will be able to speak, but no one will be able to catch anyone by surprise, so to speak, because we do understand, look, this faction firmly believes this faction firmly believes that, and we've had that discussion within our Decolonization and Constitutional Affairs Committee. I will go first to MP Grisha Heilige-Martin, and then we will come back to you, MP George.
Thank you, Mr. Chairman. Mr. Chairman, regarding the Petit Comité that we decided to enact like a few months ago, just before this new parliamentary year, is there a chance that we're going to be able to set up that Petit Comité and move forward with the discussions of democratic deficits as well, knowing that we want to be ahead of everything prior to the next IPKO, I think slated for June. Are we going to have another meeting to also set up that committee? And that committee would be great to prepare for not only IPKO, but also for the Kingdom Conference. That's one. And two, just for clarity's sake, Mr. Chairman, you listed some questions earlier. Is that going to be part of the framework when you email it to us to guide us as to what you want to pull in from us for the position papers that we're going to be presenting per factions? So it's going to be, again, repeated, because that's the first time we're hearing it during this discussion. Thank you, Mr. Chairman, just for clarity's sake.
Yes, no problem. Let me go with your second point first. What I will be suggesting to the Secretariat is based on not just the points I notice whenever we have a discussion topic, if we don't kind of throw some points there, it's very difficult to engage. So these are just some, let's say, that I came up with, but then you hear some other points. What I would ask of the Secretariat is to prepare a decision list with these different points that will then be sent to all the factions, and then from that, you can use that as your framework for the position papers you will be sending. What was your first question again, sorry? Oh, yes, about the Petit Comité. Technically, really speaking, I think the CCAD committee will probably have to handle that aspect where we'll discuss the different committees, if necessary, that would be set up. However, what this committee can do is make itself available to whoever is appointed to the Petit Comité. So, for example, if we are working on positions regarding reparatory justice and slavery, and that's on the agenda for the next meeting, let's say yourself and MP Gums are the two members of the Petit Comité, you will then use the information that this committee is giving you to then have the interactions with the other partners. I see you. Are you referring to the Petit Committees that are established on a tripartite level? Because then maybe I'm mixing it up. Let me allow you to
I
clarify.
think you're mixing it up, Mr. Chairman. It's right before closing of the last of the parliamentary year, the former chair lady of this committee, we had an agreement that we were going to have a Petit Comité to discuss the democratic deficit. I think MP Rayon Peterson wanted to be part of that we would form a Petit Comité highlighting the democratic deficits in the Kingdom Charter. That was the first initial Petit Comité we wanted to put together, but unfortunately we didn't get a chance to finalize that. And I would think that's important now more than ever for us to form that committee and then to have that discussion and list those articles in the Kingdom Charter that we want to focus on. Thank you.
Yes, indeed. Now I understand. I thought you were referring to the Petit Committees that we set up for IPKO to interact with the other countries. Okay. The Petit Committee of this committee, I believe that we will address more in the next agenda point, which is more about constitutional affairs and decolonization issues and positions of Parliament. So I will come back to that point in the third agenda point. MP George Pantaflet.
Yes, thank you, Mr. Chairman. I just had to share this because I want us to keep in mind that we are not out there on our own as an island to ourselves. We have others who we can combine our efforts with in order to get this done. Why do I say this? I was pleasantly surprised when I received an email from the chairman of the Reparations Committee of Dominica. And he stated, and I quote, "Greetings, sir. Thank you for establishing the link. Based on your impactful comments at the Parliament, it fits right into the CARICOM Reparations Commission's objectives and line of thinking. I am a member of the CRC due to being a chairperson of Dominica Reparations Committee. We welcome the Dutch pronouncements, re-apology for slavery, and possible reparations. We will establish a link with CRC's executive for future collaborations." And what happened is I was sent the email address of Sir Hilary Beckles, who is the chairman of the Caribbean CARICOM Reparations Committee, and also the vice chair. So what I'm saying, Mr. Chairman, is we should not think that we are on our own. We can also contact these persons in order to work together to achieve our goal. Thank you, Mr. Chairman.
Thank you, MP George. And indeed, I recall seeing on on a Facebook page, I can't remember exactly which one, like the 5-minute clip of your presentation at IPKO. And I think that caught the attention. It was a Caribbean, kind of a Caribbean culture and heritage page. And I think that caught the attention of others in the Caribbean. It does show that a lot of what we say and do can have impact across the Caribbean. So I think you should be congratulated in that sense. for that contribution that you made. But indeed, good to hear that our partners and brothers and sisters in the Caribbean are looking forward to, okay, St. Maarten, you kind of got the lead in this, is the sentiment I get from them, because the Netherlands, as much as I don't agree with the manner in which and even the content of the apology, it did have an impact from the perspective of the Caribbean countries are saying, well, at least you are a little further than Spain and UK and Portugal, etc. But as was discussed in IPKO, the comma, what next? And I appreciated MP Silvana's plea to the IPKO to say, don't come back to IPKO now to discuss again about slavery and talking about monuments and so on. We really need to move really further to the next steps. And I think her kind of tone was that, okay, you've apologized, but what are you going to do to fix it? And that was also my sentiment. So I think at the next IPKO, we still have to finalize the agenda and so on. In that sense, based on the decision list, based on where we see it's going, this is going to be a much deeper discussion, and hence all of your comments and the idea of the different position papers will strengthen our ability to push this point forward. I also want to say a couple things from my perspective that we need to keep in mind. The apology in terms of, let's say, maybe from a legal perspective, in the context of apologizing for slavery, is that an admission against a crime against humanity? That is a context that you hear others are pursuing. That when you apologize for something, I always give the example that if I break somebody's phone and the phone drop, you don't just say, okay, sorry, bro. And the person will be like, okay, yeah, thanks for your apology, but I need a new phone, you know? And as a matter of fact, maybe they might tell you, I lost productivity because of it. And, you know, I lost time because of it. I had to take time or whatever. I had to inconvenience someone else. There's ramifications to the damage that you do, and it is much broader than maybe how they might choose to look at it. I was following the second chamber meeting where you heard some sentiments. And again, I don't want to say that this is the sentiments of a broad part of the second chamber, but it's a significant part of the, let's say, really further right-leaning parties that feel like, no, we don't owe you nothing, and our people in Holland right now didn't enslave anyone, so why do we need to pay? So understand that there are differing opinions, especially coming out of the Netherlands, whether large or small, we don't know, but that opinion exists. So we have to prepare for those counter-arguments. Why is it that, for example, the current taxpayers in the Netherlands should be paying for this? What is the culpability of the king, if any, in this, in the royal family? What should their role be? I would like for us and encourage the members of the committee to go as deep as possible into this. There are some things that are facts that will not really be debatable. How we go about it will be debatable. Let's welcome that debate. Let's engage it deeply within this committee. And as chair, I will do my utmost together with the chairman of parliament to schedule this meeting, at least I would say 2 more times, maybe even 3 would be better before the next IPKO, so that we have a solid report that the parliament can approve. I do like the idea regarding should the committee establish or have some sort of contact or presentation, I believe with the new equipment, and I'm not sure, but we should be able to have now interactions by Zoom. Maybe one of the ideas is to actually hear from the CARICOM's Committee on Reparations and some of their views and guidance, and so that we get a bit of an outside view, because sometimes when you're in something, you kind of don't see what maybe others are seeing, as you pointed out, MP George. So I would make a note that perhaps we can also see if there's an opportunity for the committee to hear from that commission as well. And like I stated earlier, the position papers will be sent by each faction. I would then try to see if within the next 2 weeks, so let's say by the next meeting week, that the members of parliament would have received all of these different points, and then ask if you can, would 2 weeks from then be enough to then reply to that decision list? You can already start formulating your points, which would basically again say that in 4 weeks we can have these position papers. Is that reasonable for the committee members? Okay, so within the next 2 weeks, you'll receive a summary of this meeting with the points to be discussed, and then 2 weeks thereafter, we would ask members of the committee and the various factions to send those positions. So I will adjourn this agenda point because as stated earlier, we will return to this discussion. And we go over to the next agenda point. This agenda is adjourned. For agenda point 3, we have discussion on the creation of a multi-annual comprehensive plan for decolonization in accordance with Resolution 1 of the June 23rd motion of Parliament. This is IS 971 of the 2019-2020 parliamentary year, June 23rd, 2020. On June 30th, this is actually supposed to be the 30th. On June 30th, 2021, Parliament approved a motion regarding decolonization. The motion's first resolution reads, resolves to request the government to review and give feedback on a comprehensive multi-annual plan to be presented to the government by Parliament for the execution of the following. A, the resolution under the 5th bullet point of the motion of Parliament, which was unanimously adopted on July 8, 2020. The request of the President of Parliament as sent by the Prime Minister on May 14, 2021. Resolutions sub 2 and 6 of the motion adopted by Parliament November 5, 2020, prior to the handling of the budget for the fiscal year 2022. Based on this motion, the Parliament is expected to create a multi-annual comprehensive plan regarding decolonization. This would then be given to the government where, as per the motion of Parliament, it would be evaluated and feedback on this would be given. In addition, further considerations regarding the need to ensure that the Kingdom Charter in and of itself does not conflict with the right to self-determination. As was presented by Pro Swaliga Foundation, the State Secretary acknowledged the importance of abiding by Jus Cogens norms, but that the Dutch state is of the opinion that the Kingdom Charter does not violate Jus Cogens norms. Whether this is the case or not, further consideration should be given on this possible dispute in the context of decolonization and whether it should be considered as a part of the plan that the motion calls to be presented. There's also been discussion on what decolonization really even means, as there have been differing views expressed on that, on not just its meaning, but even its level of priority in terms of being at the forefront of discussions with the Netherlands by both the government and the Parliament. The purpose of this agenda is to begin a discussion on the way by which the resolution of this motion will be handled. The committee can advise the Central Committee by means of a decision list on actions to be taken, and the committee could also take the lead in drafting a plan as prescribed in the June 30 motion for the Parliament to approve. In addition to that, the committee could also consider, especially considering the need to review the Kingdom Charter from the perspective of it not conflicting with international law as well as the peremptory norm, that whether there should be additional expert help contracted by the Parliament of Sint Maarten rather than going the route of the government having to be the contracting agency to screen the Kingdom Charter. Members of Parliament, with that elucidation and discussion, again, just like with the previous points, I wanted to throw some of the different options there. The idea would be then to, within this committee setting, be able to come up with a framework for what the Parliament's position is in terms of decolonization, not just a definition in terms of a dictionary definition, but a deep understanding of what the expectations are and what the interpretation is as what it really means for Sint Maarten to be decolonized, and also in terms of the Kingdom Charter, which was stated earlier in terms of the Petit Comité, looking at that aspect of the constitutional affairs. I think indeed that is a first step that should be taken. Hopefully maybe today we can come up with exactly, well, I need to follow up if those members were selected. I think the former chair, one second. I'll follow with the Griffier to see exactly what was done in that regard, but nonetheless, the Petit Committee could be helpful, kind of like we did with the referendum part, to help create that framework. So at this time, I give the floor to members of Parliament if they have any questions or comments or discussion points with this agenda point. Yeah, MP George Panterflet.
Yes, thank you, Mr. Chairman. Mr. Chairman, the Charter itself is a clear reflection that we are not completely decolonized. We are not, if I ask the question, Mr. Chairman, are we a state? Are we sovereign? We are part of the Kingdom of the Netherlands, but Mr. Chairman, we are not a state, we are not sovereign. Because any country that has another country determining exactly their future and their destiny, that country is not totally decolonized, Mr. Chairman. And I believe discussion has been held very often in this parliament where, and look to my left, my colleague, Amy Petition, has mentioned it more than once, we have to look at the charter itself. And that's where the problem lies. We have to look at the charter and see exactly what it's in it, what's in it. That definitely it gives a semblance of equality, but I've always been concerned by certain articles when it says that, first and foremost, Article 1 says that we are the kingdom consists of 4 countries. But then you'll hear that certain responsibilities belong to the kingdom. And that's why, for me, I'm trying to figure out sometimes, when are we talking about the 4 countries and when are we talking about the Netherlands? Because articles mentioned by Pro-Swa Liga in the, more than once, Articles 44, Articles 43, Article 50, 51, you see where, Mr. Chairman, definitely when they mention the kingdom, they're talking about the Netherlands. So I believe once we look at that charter first and foremost, to ensure that it is tested against a higher law, or let me put it this way, international treaties where you see that they are not, that Sint Maarten is not a state or a so-called country that can determine her own future when you have institutions such as the Committee for Financial Supervision, which decides for us our budget. I mean, right now you're hearing that we can pass the budget and so on, but once it has been passed by Parliament, that is not the final stage. It has to go back to the CFT, and then the governor, who represents the king, Mr. Chairman. So I believe that you should start looking at the issue of the charter, and of course also look at international treaties such as the famous one of Article 73, which talks about states and so on. We are being administrated by the Dutch, Mr. Chairman. And that's a fact. So, Mr. Chairman, I'll leave it there because I know it's a discussion that can take us quite a long time, has to be in depth. There are many laws that have to be looked at, many treaties have to be compared, but first and foremost, Mr. Chairman, the charter has to be tested. Thank you, Mr. Chairman.
Thank you for that, MP George Pantouflet. Are there any others at this time? I see no need. One of the points I mentioned earlier is indeed at the center of being able to come with some sort of position as to, okay, this is what the government needs to do in terms of decolonization. I think you, MP George Pantouflet, really highlighted indeed what aspect and who, or has it been determined objectively by a legal professional, constitutional expert, or some other institution, whichever one, international courts of justice. There are many options. But to be able to go further into really taking it article by article and then going and saying, okay, especially this part of the letter from the State Secretary that acknowledges your right to self-determination trumps everything. It trumps your ministerial regulation, your landsbesluit, your this, your that, your statute. It is a sovereign right. The thing is that what she also stated, and that's what I stated earlier in the guidelines, that in the opinion of the Dutch state, it does not trample on your right to self-determination. So the Dutch state already has an opinion. So one of the things I looked at is, we talk, for example, of the geschilderregeling and so on. I guess to give it like a bit of an analogy, if there's a child that is being abused by a parent, would anyone ever suggest that the parents conduct the investigation as to whether there's any abuse? It would always be a third party outside of the family that can objectively from outside come in and say, hey, indeed, I looked at the evidence, I looked at everything, and I'm taking it, juxtaposing it to different laws and seeing that there are some conflicts here. Or maybe they come back and say, no, there is no conflict there, it is okay, it's fine. So my proposal here today is, I think that we should, the Parliament, so the committee, via the presidium or suggested presidium, that we engage via a terms of reference or something to have an institution look at this Kingdom Charter with specific questions as to whether the Kingdom Charter conflicts with that with that peremptory norm, with the right to self-determination, and if yes, in what ways does it, and if we find what those ways are, what are the remedies? Because what I think that will arm the Parliament with is that, look, guys, it's not just us that have been saying this. We have now actually, as the Parliament of St. Maarten, received this information. Maybe have then the government to me can be at play, where government to government, they could say, look, we received this from the Parliament. What's your response to this? And if the response then is that, no, we still don't agree, then there are other options. You have the International Court of Arbitration that should rule on something like this, because if you look at what the Human Rights Court has determined, and I don't have the exact quote in front of me, but to paraphrase, in case law, they have stated that if there is a violation of such, it should never be between the parties alleged to have done the violation to then do the investigation or rule on whether there is harm being done. So in the case of, for example, the Chagos Islands, you had the International Court of Justice that stepped in. And interestingly enough, one of the position papers or the written statements that were given in defense of the Chagos Islands was from the Netherlands. So we already have the written statement of the Netherlands. We know what their position is. We know what the Dutch government position is on the peremptory norm of self-determination. So I think what the other steps should be, aside from the Petit Comité going deep into this and creating a framework for, okay, what should a position of Parliament regarding decolonization look like? So not the content of it at this stage, because like we said with the referendum, the committee should all be involved in the content. But I would ask if the Petit Comité can also then help us create, let's say, chapter by chapter, these are the parts that we should go in. Let me start with that aspect first. Who would like to be a part of the Petit Comité? I see MP Grisha Heilige-Martin, I see MP Rayon Peterson, and MP George Pantoflet. So we will then have the three of them as members of the Petit Comité that will analyze, that will create the framework for basically what our decolonization. Do you want to? I don't understand what you're saying. Okay. I think maybe you might have been alluding to the timeline. I want to propose the same timeline as we've done with both of the agenda points, where within 4 weeks, this will be with the committee, and I will ask via the chairman to already kind of book us for, well, I gotta be careful because I don't know if we got Carnival by then in 4 weeks. But around that time, if the Parliament is open, that we will have a committee meeting of the CCAD committee. In addition to that, then, my proposal would also be that the Presidium is engaged together with the Secretariat to see if we can have a contracting agency that, or contract an institution that can do this analysis of the Kingdom Charter for that legal test of whether it conflicts with international law and the peremptory right to self-determination. So those will be the two things that will be proposed from this committee to the Presidium to be handled, and then once the Presidium handles it, we will inform the committee further. Again, any action that's going to be taken, we will continue to ensure that the committee is informed both in writing as well as by means of these meetings that we'll be holding. So I do look forward to the work of the committee members. To repeat again, that would be MP Rayon Peterson, MP George Pantoflet, and MP Grisha Heilige-Martin, where you all will develop and report back to the committee with a framework for what this plan for decolonization should look like and what it should include. And then we will engage with the Presidium, have the Presidium, by means of terms of reference, engage with a third party to screen the Kingdom Charter versus international law. So with that, members of the committee, we still have one pending agenda point as stated earlier in agenda point 2, which we will return to. But for today, we will close, we've closed agenda point 1, and we will now close agenda point 3. So this meeting is adjourned until further notice. Meeting adjourned.